Hi, I'm Skip Reynolds with Skipton Law, Estate Planning, and Elder Law here in Centennial, Colorado. And what I want to talk about on this video is the third part of our 10-part series talking about mistakes people make surrounding Medicaid. And in this video, what I want to talk about specifically is giving assets away to our children or others without considering all of the consequences that can happen from said gift. So one of the big issues, and I think it's one that a lot of people are somewhat aware of, and it's why they might be giving things away, other than maybe to avoid probate, is they are aware of what is called a Medicaid look-back, meaning that if you gave a gift within the last 5 years, Medicaid can technically look back that amount of time, and they can say, oh, 3 years ago you gave away X. And you need to tell them that you did this within the last 5 years. So not taking into account that 5-year look back as we're making these gifts is one of these giving assets away without considering all the factors issues. But I think one that is not recognized, maybe it's not a law thing necessarily, is when we give something away, we cannot get it back, right? It's, as a friend of mine says, non-take-a-backable. You can't get it back. Well, if you can't get it back, and let's say it's your house, because that's a commonly given thing, trying to avoid probate or asset recovery if we ended up in long-term care and on Medicaid. So we give away our house, but if I give away my house to someone else, and I want to sell, or I want to move, or I want to do something with my house, I have given up control. I have no control of whether they go with me or they don't. We had somebody that's exactly what happened. They gave away part of the house. They wanted to move. The other person didn't want them to move, or didn't want to go with the plan that they thought that they had as an agreement between them. That's a big issue, loss of control. Another one is liability risk. Now, less so than maybe the loss of control as an issue, but if my parents give me a portion of their house or their entire house and I get sued, what is now an asset of mine? That's right, their house. So they gave it to me to try to achieve some other result, not understanding all of the consequences, including the consequence of my liabilities, in addition to the Medicaid rules, etc. And another one is taxes, right? So the most commonly given asset by parents in particular to try to avoid things like probate or Medicaid risks is their primary residence. So we give away our primary residence. So let's just say, for example, that we bought our house at $100,000. That's what we call a cost basis. So they bought it at $100,000. And over the amount of time that they've lived there, let's say it's grown to $400,000. And then they give it to their children because they're wanting to avoid probate, and they're also wanting to avoid it being taken if they go to the nursing home and go on Medicaid. So let's say that they sell the house at a future time and it's now worth $500,000. There's a lot of people out there that believe, oh, when I gave it to the kids, that's where they start at their cost basis. So not my $100,000, but the $400,000 at the time that I gave it to them. Well, under the IRS regulations, that is not in fact the case. There is something called a carryover basis, meaning the amount of basis that mom and dad had is the starting point because it's never used the personal residence exemption. So instead of starting at $400,000 like mom and dad thought, it actually might be starting at $100,000. So when you sell it for $500,000, now we've potentially got $400,000 worth of capital gains. And right now the capital gains rate, say highest rate is 20%. That is subject to change. Can you see how expensive that gift might have been? So we didn't think about the potential tax consequences because we may not have fully understood it. So it's not just a scenario where we gave it away because we didn't want to lose it. We didn't understand that we could lose control, lose it to liabilities of our giftees, or potentially have additional tax consequences. Or what if you're in long-term care and you own more than one property and you gave away these properties, or you even gave away just your primary residence, and they won't give it back to you, and you need to go on Medicaid. Well, if you gave that gift within the last 5 years, it's on the books. They know about it, or you have to tell them about it, and now, bang, we've got an issue because it's non-take-backable. Unless that other party decides to give it back to you, it is something that could cause you a negative consequence for applying for and qualifying for a program such as Medicaid. So you got to be aware of all these things before you make gifts. There are things that you might not have considered that could be huge consequences for you. If you like this video, you can subscribe to our YouTube channel, or you can find this video and other videos on these Medicaid mistakes, but also other topics on our website at www.skiptonlaw.com. Or I do bi-monthly workshops talking about estate planning, wills, trusts, powers of attorney. I also talk about asset protection and Medicaid. If you'd like to attend one of those and you live here in Colorado, you can go to our website, again, skiptonlaw.com, and sign up there. Or you can call our office at 720-440-2774, and we'll get you signed up there as well. Thanks so much for joining me. Subscribe to our channel if you like this content, and I hope to see you again soon.